suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
We all need one from time to time, whether you're in lockdown or not. And David Whiting is here with you to help. Well-known Melbourne solicitor who's been answering the calls for, well, more than a decade, more than a couple of decades, I think. David Whiting, good morning.
More than a couple of decades.
Yeah, well more than a couple of decades. What's happening? Did we have any homework from last week?
No, but we did have Andrew from New Gisborne. You remember? Andrew was a client of mine. Still is
yes.
a client of
now,
mine.
Let me just bring the listener up to speed. If you were listening last week, this is an unforgettable moment. Andrew in Gisborne rang in and said he needed some advice. What happens? What should you do when your lawyer stops returning your calls? Turned out said lawyer was David Whiting. Now, let me paraphrase, David. I think you were going away to have some stern conversations back in the office. What's been resolved?
Well, I rang Andrew when I got back to the office, and on Tuesday
Finally.
we spoke again on Wednesday. Yep. He has a building dispute, and building disputes are always unpleasant and uncomfortable, and we've started a process for your view might be bringing it to a head, but endeavouring to resolve the issue. The problem, and remember this is Andrew's case, not everybody's, building disputes are always unpopular because at the end of the day they get resolved at VCAT. And so every now and then you get a case where the cost of running the matter to VCAT is, or can be, more expensive than actually going in and doing all the repairs yourself. But we'll see. We've now got a strategy for moving it on.
Good.
We are talking.
Right? I'm so glad that you're talking. Nice to clarify that, and thank you for being so generous about it. David Whiting is here to answer your questions. I've got a couple of lines free, 1300 222 774. You know how hard it is to get on and to get your question answered, so do take this opportunity. All right, who gets to go first? Jerry in Woodend, good morning to you.
Oh, good morning, Virginia and David. Look, my question, we live next door to a house that's under the Ministry of Housing, and there is a hedge that borders our property, our driveway, that's very overgrown and very high near the power line. And the Ministry's saying, look, we'll cut the half that's on the side of the property, but not our side, because there's some legal thing now about coming onto our property. So my question is... sorry, go on.
I take it it's their planting, is it, Jerry?
Yes.
So they probably have an issue with their contractors coming onto someone else's property to do work from your side. So that's likely to be their issue. So what they're saying is the only way they can get their contractors to do something is to do it from their side. So what's happening on your side that you have a problem with?
Well, it's overgrown onto our driveway, and it's very high, and it's up against power into our house.
Oh, wow. So what do you want them to do? To just simply cut it back or
trim
to remove
it? I want them to trim it, yes, to trim it. Yes, I'm 80-something now, so it's too high for me to get up. And, I want them to maintain it as it ought to be maintained.
Well, you have, and I'm not encouraging you to take this to the magistrates' court, but you do have the right to force them to remove their plantings from your property. So I suppose you might try and go, you might say to them, well, I'll give you an authorisation to come onto your property to fix it. But if they won't, then, and it is important enough, you could take the matter to the Ombudsman and say, look, here's my issue. How do I deal with this one?
Mm-hmm. In the
Victorian
past,
State Ombudsman? Yep.
Yes. In the past, they have had somebody come on the property, and there's never been a problem. And it's certainly not a problem for us.
No, but it might be policies at the ministry that makes the difference.
Yes, and it might be a new policy. Oh.
Yes.
Okay.
Yep.
Okay, thank you.
Good luck. We really hope
Thanks,
that
Sherry.
helps. Well done to you. Kate in Brown Hill. Is it Brown Hill? Kate, good morning.
Hi, Virginia and David.
Go ahead.
lovely to talk to you. Just a situation where my son had a best friend who had to leave the house they were living in because it was not safe for them. And I took her in to care for her. She's 21. And she came in with no money, no ability to pay for anything like food or anything like that. So I just did what I did. And but my son and her made an agreement that anything that she wanted, takeaway food, tattoos, piercing.
Yes, it's difficult to hear you today. It's difficult to hear you with the line that you're on, Kate. So maybe just get to the nub of the problem.
So basically, she ended up having to be moved out, and because the situation became very unbearable to live with her. And when she moved out, she had my son had an itemised list of everything that she owed him, which amounted to $2,500.
And has she paid that back?
No.
Okay.
She tore the thing up. And
all right. Well, I'm sorry, but the sound is really bad. Go ahead, David.
Kate, your difficulty is really that it's a magistrate's court claim for $2,500 against a person that your son. So the way you've described it, it's an enforceable loan agreement. I'm advancing money to you by making these payments on your behalf. So you would, in the normal course. Well, sorry, no. We're not lending her money. We're buying these things for her. So I'm supplying her with takeaway food, and I'm supplying her with tattoos. Heaven forbid, but everybody's a bit different. You could take the matter to VCAT on the basis that your son could, on the basis that he was the provider of these services and goods to her, and now wants to be paid, and you could end up with a judgment there that could be enforced. But my problem is that you've taken in a 21-year-old who had absolutely nothing. That person's now left your home, but I wouldn't have thought that their financial circumstances would have changed substantially.
Well, they've moved back to the home that the abuse was occurring in, where they had to leave urgently.
I think we just might need to be a bit careful here with identifying anything from the story that we're telling. So what's the bottom line here, David?
Well, the bottom line is that if you regard it as a debt for monies paid, then it's a magistrate's court matter, and for $2,500 against a 21-year-old who's unlikely to have any money, I couldn't recommend that you commence proceedings. If you wanted to construct it as that your son was the provider of these goods and services, then you could bring a proceeding in VCAT under the civil claims jurisdiction and claim the same amount of money. So if you want to pursue it, try the VCAT route. If you're unsuccessful there, it's a magistrate's court, and I wouldn't recommend it.
All right, so David Whiting is not recommending going any further with this one. It may just have to be lost money, which I get and understand would be deeply frustrating. Sorry about that. Di in Williamstown, how can we help you today? Hello.
Hi, thanks for taking my call. Yes, I've moved into a flat in Williamstown. It's an upstairs flat with a balcony and a split system heating, cooling. And next door they have a chimney, unfortunately, with an open fire that they light on the weekend. And I've been to the council, and I was really disappointed that the onus seems to be on me to go talk to the neighbours about their open fire.
What does the open fire mean for you, Di?
The smoke, our whole flat is full of smoke.
Where does it come in from, do you know?
Their chimney. They've got, because we're on the second floor, they've got the big Ponderosa beautiful home next door, but their chimney, when the wind blows and they've got an open fire, comes literally into our lounge room.
With the windows closed, does it come in?
Yeah, because, we've had some pretty cold nights. and I've had to turn off the heating. But what I was really disappointed was it said they sent me a form, Hobsons Bay Council, saying fill in the form, but we prefer you to go and talk to the neighbours. And I thought, oh, well, this is sort of an environmental thing. I can't, I've only just moved in. I don't know them. And and it says, you know, how often? Well, you know, it might only be on the weekend, but yeah, I just
But it's
don't know.
It's enough to cause trouble. Okay,
Well,
let's see what David says.
Yeah, you certainly have the right to make a complaint to council about smoke.
Yes, I did.
They will have a local law, and yes, but they're simply saying, look, at the first instance, we'd rather you dealt with it. So you're going to have to give them, it's a little bit like noise pollution. They ask you to keep a diary. When does it happen? How long does it happen for?
Yes, I understand that.
And then they will add it to the list of all of the other things that they need to do. So, yes, they do have the right to do something about it. There's likely to be a local law in Hobsons Bay relating to it, but you're going to have to persuade the bylaws officer to take up the case for you.
Yeah, that's how
you also
it
have the
feels.
right... Yeah, well... Yes, but I suppose it's if you look at the number of people who live in Hobsons Bay and the number of issues that need to be dealt with by the bylaws people, you're, I suppose, one of many, Di.
Yeah.
And so the question
and so what
would
do
be,
I
how
do?
do you...
If it's not often enough, like if it's only in winter, because we've only been here a month, so it's been on the weekend, I'm just not sure how... like the whole stairwell's full of smoke. We've had to sit in the cold because it fills up the whole room. I'm just not sure.
Is there anything in your property that could prevent the smoke coming in?
Only turning off the heater, it lowers it. That's the only thing that we can do. It's really... it just seemed like they're asking me to prove something that I can prove it, but I don't know if that means that I've got any recall on it. I suppose I just sit in smoke. I don't know.
Well, I mean, the law gives you the right, gives you an action against your neighbour as well. So you have a private action in nuisance against your neighbours, the people who light the fire, for the damage caused to your property. So you know, we often talk about self-help is often certainly a conversation is probably a better start to a relationship with your neighbour than a visit from the bylaws officer. So I think the starting point would be at a time on the weekend when the smoke is there, invite them in.
Yep, that might be a useful way to start. Yeah.
And this
I
might
don't
be
feel
something that could be...
doing that. Yeah, okay.
It is a hard thing to ask people to do, David Whiting. Some will feel very confident to be able to do that. Others will be quite intimidated by the prospect of it.
Quite intimidated, actually. It's a very... It's a very substantial property. I live in a little tiny flat. Yeah. I'm an older person. I don't feel very confident to go and talk to them.
All right, let's hear last word from David.
Is there someone who can go for you, Di? Is there someone who can go for you, someone who isn't wearing a uniform from Hobsons Bay Council?
Not that I can think of off the top of my head, but that's probably a good point. I mean, whether that would stop them. I was hoping that someone could go and talk to them about their actual chimney and see if they're... Yeah, it seems quite... Yeah, the wood seems quite... Yeah, not plain.
But at the moment, Di, they're probably not aware they're causing a problem.
Yeah.
I've got some comments here coming in on text, and then we'll have to leave it here and wish you all the best of luck, Di. But they're saying a split system doesn't bring in fresh air. It's totally isolated. You must have other leaks.
Oh, no. It's, there's plenty of drafts in this old place. Right. But it's worse when we've got it on. But,
okay.
It's really quite... I was just surprised that I had to sort of start a a big sort of campaign to get it sorted. But yeah,
I know,
maybe I'll have to find someone. Thank you.
will.
Thanks very much.
That's
Bye.
all right.
Thanks, Di.
Sorry that we haven't been able to help you any further here, but we hope that's useful. Christine in Brighton, what's the issue? Good morning.
Oh, good morning. Firstly, I want to apologise because I've got a high squeaky voice anyway and I'm really nervous, so it's going to get squeakier. Like a lot of baby boomers, we were at the point where we wanted to consider downsizing, so we looked at some of the inner suburban, well, actually South Bank, right near you, Virginia, apartment towers that are being built, and we bought one off the plan, which gave us 2 years to get our head around moving from the burbs to inner city.
Yeah, let's get to the problem, Christine.
Okay. Then another apartment complex came up that suited us much better, closer to where we live. The same agent that sold us the first one said, well, she actually took us to this second one and said, this one will suit you better. And we said, well, we cannot afford to buy two and we don't want to buy two. What can we do? We'll sign the other one. And she said, don't worry about that. I'll offload that for you. I'll do all the arrangements.
Yeah.
You just sign up to this one.
And so what's happened, Christine?
Did you sign anything, Christine?
With her?
Yeah.
To offload it? No.
Yep.
Which brings us to the problem. Fast forward 2 years, the first apartment building settled. The second one hasn't, and she did admit she was much more she was getting a much higher commission by selling us the second one, and we just assumed that was so she could facilitate her second commission. To fast forward 2 years, the first apartments have settled, new owners, blah, 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 everything went smoothly. Now she's saying...
And you didn't settle that one? You didn't complete that one, did you?
No. She did find us other buyers. She arranged the solicitor, the legals to transfer ownership, blah, 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 everything. But now 2 years later, I'm getting between 4 and 10 phone calls a day saying, pay me $10,000 for making it all happen.
Okay, David?
Well, no, just no. In order to be liable for commission, you need to have signed an agreement.
Which we never did.
It's just that simple. And the answer would be, show me a copy of the agreement under which I agreed to pay you commission. And that's basically it. It's Section 50 of the Estate Agents Act.
And will there be a piece of paper somewhere with your signature on it, Christine?
Not to my knowledge.
Well, then that's it. David, is it?
No, that's the end of the question. Have a look at Section 50 of the Estate Agents Act, which basically sets out that what needs to happen in order for a commission, in order for an agent to seek to be paid commission or a fee.
And how do I stop the harassment?
You might complain to the principal of the agency about their representative, and if you really want to, you can make a professional misconduct allegation to the Business Licensing Authority.
Christine, good luck with that one. John in Ascot Vale, good morning to you.
Good morning, Virginia. Good morning, David. Thank you for taking my call. I can't remember how long I've been listening to your show. I can remember when you did the whole show by yourself when Mr. Fane QC had an on-air incident. So that's how long ago it was.
Can I say, John, that was about 3 minutes, okay?
Oh, you did the whole show?
No, I didn't. John, Virginia, John was on the program. John and I would go into the studio before 10 o'clock, and John would interview the editor of the local newspapers. And while he was about to start that interview, he decided that he would lick an envelope and had an allergic
yes, I know.
reaction
That
to
was
the
a
glue.
famous incident. John, let's get to your question. How can we help you?
Sorry to diverse. David, if in the unfortunate case I have a car collision with another driver, Am I able to ask that driver to see their driver's licence?
There is no incident that's actually happened that we're talking about.
No,
John.
no. This is hypothetical.
Right, this is, okay, we're spending time on hypotheticals. David, go ahead.
You're required to exchange names and addresses, but I'm not required to prove my name and address.
Okay. John in Ballarat, good morning to you.
Oh, hi, David in Virginia. Thanks for taking the call. When you join a right-of-way which is owned by a sole proprietor in Estate v. Simple, who purchased it in 1890 and died in 1930, in 1891 that owner created 2 grants of easement on title for some of the adjoining land to that road. Today there are 4 parcels of land or part thereof adjoining that road. 2 of the 4 parcels, including ourselves, have an easement on title for the full frontage to that road based on those easements. The 3rd parcel of land has an easement for only 3.66 metres of its 22.3 metre frontage, and the 4th parcel has no easement. My 2 questions. Can the adjoining land with no or only part easement on title access the road at any point where that land fronts the road? And secondly, how do you change the restrictions, if any, around the current limited easements on the road?
You can change, when you're talking about a road, you're talking about a right-of-way that sits on somebody's title and what we call the servient tenement. And the dominant tenement is land that has the right to use the servient tenement, right? Now, there can be an agreement between the owner of the dominant tenement and the owner of the servient tenement to change the terms of that easement as between those 2 properties. And if you've got a person who's entitled to use 4 metres of the 22 metres, then that doesn't give them the right to use the other 18.
Right, and given that the current owner died in 1930, will that right of way, how does that affect any change?
Would need, I think it would be unfair to describe the person who died in 1930 as the current owner. You might describe him or her as the last registered owner.
Thank you.
You would need to try and work out who the property belonged to. And somebody might apply for a title. Is it maintained by council?
It is alleged, but no.
Well, if you look, you're in Ballarat. If you look, the City of Greater Ballarat will keep a register of its assets, and included in its assets will be all of the lanes that it says it owns. So start there to see whether council owns it. Yes. And if it's council property, then they may be prepared to confer rights of access on everybody.
Yep. All right. Okay. Appreciate that.
Good luck with that. I think we can probably just squeeze in one quick last one. Terry in Greensboro, if it's not too complicated, but it may be. Good morning.
Good morning. Hi. I own 2 properties in a business name, which is in a unit trust, with my husband's business partner. My husband passed away 11 years ago, and I want to sever the ties. My question is, as a beneficiary, can I transfer one of the properties into my own personal name or my family trust name without paying capital gains or stamp duty?
So you've got 2 properties that currently stand in a company name.
Correct.
The company acts as trustee of a unit trust.
That's right.
And the unit holders are discretionary trusts for the benefit of you and your partner.
No,
for you and your husband's former business partner.
That's correct. Yes.
Okay. Good. Yes, you will. You will inevitably be paying. There is capital gains tax payable on the distribution of an asset from a trust to a beneficiary.
Right.
And there may or may not be stamp duty payable. So there will be tax implications.
Okay.
And as a general proposition, you will pay duty or stamp duty on the transfers at value, and you will also probably pay capital gain. In fact, you will pay capital gains tax as well.
Okay. So no exemptions or anything as a beneficiary at all?
No.
Gosh. All right. Well, thank you very much. I appreciate
Okay.
that.
Thank you, Terry.
Good luck. Probably not the news that Terry wanted to hear. But David, thanks so much for all that advice. We'll see you next week.
Thanks, Virginia.
David Whiting, well-known Melbourne solicitor there.